Good day, everyone. Welcome to this webinar on compulsory licensing provisions in national patent legislation and content analysis. I now give the floor to Professor Carlos Correa.
Well, thank you, Viviana. So let me also welcome all participants on behalf of the South Center and thank already in advance our speakers, our commentator, and also our moderator. So this is an important subject on which the South Center has worked a lot, and we are really very pleased to co-organize this event with the Global Development Policy Center of the Boston University, under the auspices of which the study that will be presented has been elaborated on. This study is really unique because it does a very in-depth examination, a very in-depth study of the compulsory licensing related provisions in the patent laws of 15 middle income countries. It has not been done before. Of course, I leave to the authors to present us the scope and also the findings that they have obtained out of this study. Let me just make a few observations. Of course, it's needless to say that compulsory licensing is a legitimate tool in the context of patent law. It's also used in other contexts of intellectual property law, such as in copyright law. And in the case in particular of patent law, it's an important tool in order to mitigate the legal monopolies which are conferred by patents. So the first observation I'd like to make is that some people think that compulsory licenses were established for the first time by the TRIPS agreement, Article 31. In fact, the first patent law adopted in the United Kingdom already contained provisions for compulsory licensing. That means that this was introduced in 1623. And after that, many patent laws in Europe also adopted this concept of compulsory licensing. Interestingly, when it was adopted under the UK law and other national patent laws, the basic ground for the grant of compulsory licensing was the lack of working of a patent. So at that time, patents were conceived as a tool not only to promote invention, but also to promote actual working of the patent in the territory where the legal monopoly was granted, meaning that it would lead to industrialization, technological development, so on and so forth. This was so strong at that time that perhaps you may recall in the French law of 1844, and this was followed by other patent laws. In the case that the patent was not worked within 2 years, the patent will just lapse. And so it was even harder than the compulsory licensing. In fact, in the revision of the Paris Convention that took place in 1925 in The Hague, the concept of compulsory licensing was introduced. And the objective of introducing this concept was to mitigate these provisions under the French law that would lead to the lapsing a patent if there was no working. So just to mention that this is an old institution. When negotiation of the TRIPS agreement started in 1986, actually many countries around the world, including developed countries, have in their patent laws compulsory license provisions. As you know, Article 31 of the TRIPS agreement also incorporated not the concept of compulsory license because it has reference to other use. This language was not used. But interestingly, the provision of Article 31 got support not only from developing countries, but also from the United States, which in fact, and perhaps surprisingly for some, is the country where the largest number of compulsory licenses have been granted in the world. And in particular, you can see the influence of the United States in the incorporation of the concept of government use with a public purpose, and also in the provision regarding the particular conditions under which a compulsory license can be granted in the case of anti-competitive practices. So the second comment I'd like to make is that, of course, compulsory license is provided for in patent laws, as this study is working on. But also, compulsory license may be granted under competition law, and this may not be exceptional. In the case of the United States, for instance, as I mentioned, a large number of compulsory licenses were granted in implementing these competition laws. And in fact, the South Center published a paper that I produced many years ago in 1999, where there is a study on the practice of the United States at that time. And later on, Professor Reichman from Duke University published in 2003 a paper in which there is also a very broad analysis on how much and extensive the United States had used compulsory licensing, in particular to correct anti-competitive practices and also for the government use. And also there are other countries such as Italy that show that competition law can be used in order to grant compulsory license. The third observation is that despite that compulsory license actually, as I'm mentioning, originated in Europe, and they have been extensively used by the United States. The fact is that when developing countries have used the system, the compulsory licensing, or even attempted to use it, they have been subject to political pressures, indicating that compulsory license was a tool of last resort, that they were damaging the intellectual property protection, so on and so forth. The case of Thailand is quite illustrative in this case when they granted the 7 compulsory license, and more recently the case of Colombia, when Colombia intended to grant a compulsory license in connection with imatinib. They were subject to very strong pressure by the United States, and perhaps our distinguished commentator can also make a comment on this. Therefore, the fact is that developed countries have opposed for a long time on this, but I think there is an interesting development, and this is that during COVID-19, as you know, there was a request by developing countries of a TRIPS waiver, in particular led by South Africa and India. And the response by the European Union in particular was, well, let's not go to a TRIPS waiver, but let's use the compulsory licensing. And then interestingly, from being an opponent to the system, the European Union became a promoter of the system. And as you may recall, in the end, the TRIPS waiver was adopted very late, in fact, and in a very narrow manner, actually brings some adjustment to the compulsory license system. And more recently, the European Union has adopted a new regulation in order to grant wide European-wide compulsory license in some cases of crisis. So it's an interesting development because it shows that there has been a change in the perception regarding compulsory license, and also the USTR reports on Section 301. At one point, they dropped the negative comments about the use of compulsory license. So this has to mean that the perception, even by developed countries, regarding the legitimacy of this tool has changed in the last few years. And then my last point is that many commentaries, many reports, including some of the publications by the South Center, have noticed that compulsory license have not been used in many developing countries, although there were situations in which it have been useful in order, in particular, to increase access to medicines. So there are different explanations for this. In some cases, political pressures I have referred to before. The fact that local companies, in some cases, they may not wish to be blacklisted if they enter into a request for compulsory license because they may not be able to get the involuntary license. The fact that many countries have been benefiting from a voluntary license, in particular through the system of the medicines patent pool. So there are many reasons, but one important reason is probably to be found in the procedures and also the substance of the provisions that allow for the grant of compulsory license in national legislation. This is in particular the subject of the very excellent study that has been prepared and that will be presented right now. So thank you very much again for your participation. Again, I repeat, we are very, very glad for this cooperation, and I hope you have a very good conversation on the importance of compulsory license and the improvements that may be introduced in order for further use of this system. Thank you very much.
Thank you so much, Carlos. And thank you to thank you to Viviana and Anna at the South Center for your support in helping this come together. So I am just the representative of the BU GDP Center primarily, and this project represents work by members of our working group on trade and investment treaties and access to medicines, and other collaborators. And so I'm excited to introduce to you Deb Gleason from La Trobe University, Bridget Tenney from the Nossel Institute of Health, Warren Kaplan from the BU School of Public Health, and Brooke Baker, who is Professor Emeritus at Northeastern University. And we'll be just going through, starting with Deb, we'll be going through the substance of our report, and then we'll be able to have the opportunity for some discussion afterwards, and then some Q&A. And with that, I will turn it over to you, Deb, and I'll run the slides, so feel free to just tell me if I'm not changing them quick enough.
Thank you very much, Carlos and Rachel, for the introduction. So I'm Deborah Gleason from La Trobe University in Australia. And thank you so much for the opportunity to speak to you today about our report on compulsory licensing provisions in the national patent legislation of 15 middle-income countries, published by the South Centre and the Global Economic Governance Initiative of the Boston University Global Policy Development Centre. So it's our custom here in Australia to acknowledge the traditional owners of the land from which we're speaking. So I'd like to acknowledge the Wurundjeri people of the Kulin Nation and pay my respects to their elders past, present and emerging. Next slide, please, Rachel. So our project asked the question, to what extent have the 15 middle-income countries that we studied adopted provisions in their compulsory and government use licensing laws that are likely to maximise the effectiveness and usability of these laws for the purposes of protecting public health? And compulsory licenses are authorisations granted by governments that allow either the government itself or a third party to work a patent without the consent of the patent holder. So they're a very important mechanism for enabling countries to provide access to medicines for their populations. And the study explores the extent to which the representative countries that we've looked at have been which have been excluded from voluntary licenses for many drugs, to what extent they have legal rules that facilitate or obstruct the effective deployment of compulsory licenses to address emergencies and other public health needs. And the main purpose of this project was twofold: to gain an understanding of the key characteristics of the compulsory licensing provisions in national patent legislation in the targeted countries, and to compare that national practice with best practices as recommended by experts. So next slide, please. Thank you, Rachel. So at the formation of the World Trade Organization, members signed onto an agreement called the Agreement on Trade-Related Aspects of Intellectual Property Rights, or the TRIPS Agreement. And this agreement was a profound change in intellectual property at the global level, because it set a global minimum standard of 20 years for patent terms, among other standards. It does include some transitional arrangements for developing countries and a developed country commitment to provide technology transfer and financial assistance to developing countries. But as a result of the TRIPS agreement, countries really struggled to gain access to medicines for major infectious and non-communicable diseases. And this was especially visible in the lack of access to HIV antiretroviral therapies in low and middle income countries. Access to HIV medicines in Africa was delayed by more than a decade. More recently, the COVID-19 pandemic really brought the impact of intellectual property barriers, including patents and other barriers like trade secrets, into sharper focus. So during the COVID pandemic, we saw supply bottlenecks with very limited supply because the companies that were making things like COVID vaccines were in very tight control of the supply, and there was very limited voluntary licensing and even contract manufacturing. We saw high-income countries hoarding the limited supplies that were available through advanced purchase agreements, really starving COVAX of doses and limiting that supply available for low-income countries. And we saw high prices for vaccines as well, with companies really retaining way too much power over, supply and also prices. And that really played out in terms of the very inequitable distribution that we saw of COVID-19 products, especially for low and middle income countries. So there were a lot of factors that went into that inequitable distribution, but one of the key factors was the monopoly rights established through countries' intellectual property rules and the reluctance of the rights holders, the companies, to engage in voluntary licensing and technology transfer. And despite this, resulting vaccine apartheid, attempts to try and redress that problem weren't very successful. And even in the negotiations on the pandemic treaty at the World Trade Organization, we've seen, although there were some provisions proposed for that treaty that it really addressed the issue of IP barriers, we saw that really watered down a lot during the negotiations, and most of those references to IP omitted from the final text. So although TRIPS presents a major barrier to access to medicines, there are flexibilities within the TRIPS agreement that countries can use to increase access, and that can be better used in future pandemics and other situations where countries need to make access to medicines available for their populations. So these flexibilities allow countries to adopt measures in their domestic law to increase access to essential innovations. And the compulsory license is the most widely discussed in the literature. So a compulsory license is a government-granted license for a local firm or the government itself to use or manufacture a patent-protected innovation without authorisation from the patent holder. So as I mentioned, the TRIPS agreement presented a profound global shift, particularly given that many countries didn't allow patents on pharmaceutical products before that time. In the middle of the 20th century, there was wide disagreement at the World Intellectual Property Organization about whether intellectual property rules at the global level should be globalized, or whether countries should have domestic flexibility and technology transfer should be promoted. The pharmaceutical companies and the countries that host these big multinationals lobbied hard during the TRIPS agreement negotiations, and the outcome was that the raised global standards applied as a baseline threshold. But we did get these flexibilities in terms of compulsory licensing provisions, which are outlined in Article 31 of TRIPS. And the rules for compulsory licenses in TRIPS allow that member states can establish any grounds for issuing compulsory licenses as long as the procedural rules in Article 31 are followed in the way that they're implemented. And common grounds include anti-competitive behaviour, failure to work the patent, government use, and public interest or emergencies. Usually there's been no export allowed under compulsory licensing, but a waiver introduced in 2003 and subsequent amendments to the TRIPS provisions allows export to countries with insufficient manufacturing capacity, although there are additional rules around how those provisions can be used. So next slide, please. Thank you. So although WTO member states have the legal rights to use compulsory licenses in a range of different circumstances and have the freedom to determine the appropriate circumstances in which they should be used, compulsory licenses have been underutilised in the countries that need them most. The initial attempts of countries to use them were met by very strident opposition from industry and from rich countries, especially the United States. And upper middle income countries have not been really systematically using compulsory licenses, which is a problem given that upper middle income countries are usually excluded from voluntary licenses that are offered by pharmaceutical companies, and also from many of the patent pool agreements, like the those of the medicines patent pool. And in fact, high-income countries are more likely to use these types of mechanisms and use them during the pandemic, particularly the US, which issued quite a few government use licenses. So the reasons for the underuse of compulsory licensing are really diverse. We go into that in a little bit of detail in our report, but they include political pressure against upper middle income countries who use them, and Bridget Tenney will be talking us through a bit later in the presentation how that's taken place with Thailand. But we've also seen that the procedural guardrails that are outlined in the TRIPS agreement make it very difficult and very lengthy for countries to actually invoke these provisions and issue compulsory licenses. And many countries have judged that it's not worth the effort, and that perhaps they should just negotiate voluntary licenses where they can, and not go down this path of issuing compulsory licenses. And we've also seen that countries have not necessarily implemented the full flexibilities in the TRIPS agreement in terms of the way that they've put these compulsory licensing mechanisms into their national law, and haven't taken all steps that they could have taken to make them to make it inclusive and easy to use. And that's really the focus of our study. So thank you, Rachel. I'll hand over to the next presenter for the methods part of the presentation.
Thank you, Deborah. Excuse my voice. It's early in the morning. I'm Warren Kaplan. I'm at the Boston University School of Public Health. I'm also a former patent attorney, which is quite entertaining for me to talk about compulsory licenses, as I've worked at various law firms in Boston and at Biogen, biotech company in Cambridge, and at no time have we ever talked about compulsory licensing in anything in my private sector. So it's exciting and important to discuss this subject. So I want to briefly go over the study design. This is an observational study where data was extracted from WIPO-Lex, that website that has intellectual property laws and various policies dealing with compulsory licensing, among other intellectual property issues. If you go on WIPO-Lex, there's a drop-down menu that has various titles, and we looked at essentially all of them that had anything to do with intellectual property. Rachel downloaded these documents. So we looked at about 15 exactly, or approximately, I mean, a little bit more, 15 countries that were not usually included in large-scale voluntary licenses. Specifically, we did look at Gilead's exclusions of their voluntary license during COVID, and those are in large part the countries that we looked at. We also looked at countries that had the largest populations, the inference being that they would have increased capacity to issue and deal with compulsory licensing. And I think somewhere down the road is a list of the countries that we have. So we extracted data based on search terms using, in quotes, best practice of compulsory license provisions. And the next slide, I think, which you don't have to switch yet. And I'll go back to that. It's basically a consensus. That's why we put best practice in quotes. It's certainly a pro-public health search terms, but we use this best practice provisions to facilitate data extraction and collection about national compulsory license laws. We hired some research assistants from the Boston University Law School to review the relevant documents. It was in English, French, Spanish, Portuguese, and I believe Arabic were the folks who were able to analyze this and actually translate it for us. Findings were double checked and triple checked by Rachel and myself. I think Rachel did the triple checking, and selected findings were sent out to some experts in other countries, which you can see there, to get more additional information. Okay. Next slide. And so again, it's in quotes, but this is, we relied on a consensus laid out by the Max Planck Institute and Professor Correa, as well as Brooke. And this is just a brief summary of what we mean by best practice. Generally, we look for easy-to-use procedural provisions without legal obfuscation. They were clearly laid out, or we intended them to be clearly laid out, without long timelines or additional procedures. That's one definition of what we thought was a best practice. The second is that these provisions included both broad grounds and specific grounds, but multiple specific grounds, not just one or two, related to medicines, health, or related issues. And that's a broad term, but we wanted to make sure we encompassed various subject matters, but certainly including medicines and health, as legitimate reasons for issuing compulsory licenses. And that third bullet point relates to broad potential scope and use. And you could see that it would allow, for example, licenses on multiple patents at once, methods of use, methods of making, final product, and on pending patents, which, as a former patent attorney, that's interesting, certainly patent applications or pending patents, but that's really broad and very interesting, and allowing license holders to import the product and allowing license holders to export the product according to TRIPS 31 bis. So that's the scope that these best practices were very expansively thinking about. And that's fine. The next slide shows a table. I hope people can read it. Well, I know there are 5 vertical columns, and each column deals with a different breadth of ground. So I'll just read it. General exploitation, anti-competitive remedies, public interest, emergency, and government use. And each vertical column lists the various grounds. For example, under general exploitation, I'm not going to read the whole thing, but non-use, insufficient use, not meeting domestic demand, suspension of use, excessive pricing as one ground for issuing a compulsory license, refusal to license, failure to locally work, as Professor Correa mentioned very early on, and dependent patents, which are important for sure. And you can see at the bottom, we ranked them, we numbered these. And we thought that some vertical columns demanded or required slightly more counting than others. But you can see then these are the 5 columns and the different grounds for use. And I'll let you look at that for a second, but I'm not one to read, to be honest, to read these table slides. But you can see, for example, government use, extreme urgency, general public interest, and it goes down, public health, pharmaceuticals, serious illnesses, and so on. Okay. So we scored this, and this is, reasonable people might differ as to the actual numbers, but for sure, we scored various points more than others. In particular, no prior negotiation with the patent holder is required. That was ranked 1 more point than some of the others. So you can see going across that for different categories, no prior negotiation with a patent holder, that's required for emergencies, for government use, as an anti-competitive remedy. That's how we scored it. And vertically, you can see the numbering that we gave, but the number 2 are those that we thought were important to emphasize. So for example, I'll go to the bottom. In lieu of a judicial review, where available, these licenses could be administratively reviewed, and we rank that as a 2 instead of a 1. And again, challenges, well, no, the challenge to the grant of a compulsory license if does not allow injunctive relief. In other words, there's no suspensive effect to challenge a compulsory license. That we thought was interesting, and we labeled that as a 2. So that's the way we scored it for ease of use. The next slide, which I think is my last one, is scoring the scope of use flexibilities. And again, I'm not going to read every one of these, but you can see the 2s, which we thought should be emphasized as a best practice, were licenses granted for all patents related to a final product. We scored that as a 2. The license allowing export of non-predominant quantities, that magic language found in Article 31, we label that as a 2. Licenses allowing export beyond non-predominant quantities to remedy anti-competitive issues, we label that as a 2. And the highest ranking was licensing allowing export beyond the non-predominant quantities under 31 bis. We rank that as a 3. As we did at the bottom, allows for Article 31 bis importation. And that's how we scored it. And I think that's my last slide, but you can see how going forward in some subsequent slides, how we dealt with this numerical point score. So I think that's it for me.
Yeah, thank you so much, Warren. And that sets us up very well to talk about some of our findings. And so I'm going to walk through those findings in about approximately 3 parts, and I'll turn it over to Bridget for some concrete examples, as Deb hinted at earlier. So just preliminarily, all 15 of our countries have compulsory licensing laws, and that's not super surprising given that all except Algeria, I believe, are WTO members, and Algeria is a non-member observer. Previous studies is consistent with previous studies that suggest that compulsory licensing laws as a category are extremely widely adopted. So many countries in the world have them, and we've already talked about some of the basic reasons for compulsory licensing laws. Most compulsory licensing requires certain procedural constraints, in particular prior negotiation with the patent holders. Except as Warren just pointed out, in certain contexts, it's allowed to not have that, requiring remuneration for the patent holder, requiring revocation when the circumstances that give rise to the patent no longer exist. So there are a few other constraints around this, but there are also, as we have been emphasizing, a lot of flexibilities within those procedural constraints. And so we'll get into that a little bit. What is important, and maybe the most fundamental finding of our paper, is that while there have been some adoption of TRIPS flexibilities around these ideas, there are none of the countries have maximized policy space to deploy compulsory and government use licenses. So this is my attempt to sort of walk through these findings that we made. So first of all, we sought to visualize the extent to which countries adopted the broadest possible breadth of grounds for issuing compulsory and government use licenses. And this, I'm just going to go back a few slides to show you which scoring we're talking about here. This is the breadth of grounds scoring. And these spider web diagrams, by the way, are courtesy of our other co-author who couldn't be here with us today, Veronica Wirtz, who's also at the Boston University School of Public Health. So I just want to acknowledge her work in particular on these, and sort of thinking about these and helping to create these figures. Anyway, so we sought to visualize the extent to which countries had adopted this the breadth of grounds for issuing these licenses, we know that TRIPS allows significant flexibility for countries to establish their own grounds for issuing compulsory licenses. And the broader the grounds, the more options a country can have to issue those licenses. And so, as we already highlighted, there are 5 general license categories, and each of those general license categories are at the nodes on the spider web. And so to visualize it, we scaled the scores so that the maximum number of grounds in any category corresponds to the external node on the spider web. And as you can see in this diagram, to be a little more specific and concrete, Colombia has the maximum number of grounds allowed for public interest licenses. Almost the maximum number for general use or exploitation licenses, but only about half the possible grounds for anti-competitive remedy or for emergency use. And so Colombia is there in the red shape there, the red 5-sided figure, if you will. So we can contrast this with Panama, which has the maximum number of grounds for emergency use licenses, but no public interest license options at all. So these web diagrams can act as a sort of proxy for the literal policy space that a country has to issue compulsory and government use licenses. And we can see here for our countries in Asia, the countries with the largest breadth of ground, or the largest area within the shape, are Thailand and the Philippines, and they have especially broad options for government use and public interest licenses, and that will become the importance of that will become even more apparent when Bridget talks about the experience of Thailand. And then the remainder of our study countries, which are sort of regionally diverse, but we group them together for purposes of sort of ease of visualization: Algeria, Jordan, Romania, Turkey, and Ukraine. Almost all have relatively limited grounds for issuing licenses, but a handful have pretty broad public interest grounds, like Ukraine, Turkey, and Algeria, and Ukraine and Jordan have also broad emergency use licenses. So you can see Romania in the black shape as the smallest and the smallest area, and therefore the lowest breadth of grounds in each category. So what is especially, not as maybe visually interesting, but especially important for our purposes, we also cataloged the number of health-related grounds for issuing compulsory licenses. And and Warren pointed out when he was talking about our scoring that some of these aspects of compulsory licensing laws we weighted more because they were more important for the purposes of public health. And so these particular breadth of grounds were weighted more for each country. These types of grounds for issuing licenses were weighted more for each country because they had such a specific application for the purpose of access to medicines. And you can see that these public health or medicines licensing provisions show up under 3 specific categories: the public interest category, emergency license category, and a government use category. And all study countries except Peru have some reference to either public health, serious illnesses, or pharmaceuticals. And what's interesting, the Philippines has a reference to public health or illnesses or pharmaceuticals in 3 separate spaces in their law. So you can see that you can adopt those flexibilities in different ways. All right. The second major category of findings was in the ease of use. This is the procedural aspect that says this is how we assessed how easy it was for petitioners to request and for government actors to grant compulsory and government use licenses. And these generally included provisions that laid out limited timelines and clear guidelines for negotiations, contract terms, and remuneration. Some of this Warren already ran through. These might increase the likelihood of granting the license by shifting the burden of proof to the patent holder, or allowing presumptive or mandatory licenses. And then, of course, as Warren did mention, the administrative review provision, the idea that that rather than a judicial review of a challenged compulsory license, it could be administrative, which is a little bit faster, a little more streamlined. So in the area of, so this is a summary of all the procedural flexibilities. It doesn't break it down by the 3 separate types of procedural flexibilities that we assessed, but you can see there's a diversity in adoption of those flexibilities. So China has roughly 1/8 of the total possible, compared to Ecuador, who has over 1/2. But those, even in that scale, there is a lot of diversity in the area of petitioning and granting flexibilities. All of our study countries have licenses that don't require prior negotiations. That's because it's built into the TRIPS agreement pretty concretely, specifically for emergency use and government use licenses. But there are a few other examples. So Argentina and Ecuador are two countries that include a limited timeline for requiring prior negotiations and provide remuneration guidelines for the licenses, just so that things are a little bit more clear. Ukraine provides remuneration guidelines specifically for compulsory licenses involving medicines. And so you can see how countries have in diverse ways adopted these flexibilities and tried to make them their own. So the sort of the third main category of findings here are the substantive or scope of use flexibilities. And these are ones which relate to the scope of application of any particular license. Here you can see the variation between the countries is a little narrower compared to the procedural variation, but still you see Mexico at just under a quarter of the possible flexibilities. And we see Romania with the most. You see Ecuador, which had the most procedural flexibilities, is still pretty high up there, above 50%. So Ecuador seems to have a pretty decent compulsory licensing law. So the scope of application flexibilities means, for example, whether a license may be granted for pending as well as granted patents, and Warren mentioned the uniqueness of that provision. Whether a single license may be granted for multiple patented components as well as a final product at once, and then the import and export options. There was only one country that had this option of allowing compulsory licenses on pending as well as granted patents, and that was Algeria. Argentina was the only study country with a provision that allowed compulsory licenses to cover all patented components as well as the final product. And there were, and 6 of our study countries had comprehensively adopted the TRIPS Article 31 bis standard, which allows for export, or allows for the issuance of export-based compulsory licenses. And those countries were Argentina, China, Ecuador, Jordan, the Philippines, and Turkey. So in each of the categories, you can see there's a great diversity in terms of adoption of the flexibilities. Again, no single country stands out in all categories. But even the highest scores, especially in scope of use and procedural flexibilities, barely exceed 50% of what could be possible. And so with that, I'm going to turn this over to Bridget to talk a little bit more about compulsory licensing in practice.
Okay, thanks very much, Rachel. Hi, everyone. I'm Bridget from the Nussel Institute for Global Health at the University of Melbourne. As Deb said, it's customary for us to acknowledge the traditional owners of the land, so I will do that. I'm on Bunurong land and want to pay respects to elders past and present on this auspicious day where, for the first time ever, Australian government has signed a treaty with Indigenous peoples in the state of Victoria. So I just want to acknowledge that. So moving on to the case study of Thailand and looking at how government use licenses are actually implemented in practice and how the Patent Act works for or against that. So the Thai Patent Act in particular, as Rachel has outlined, has very broad grounds for government use licenses. In fact, the broadest scope of public interest and government use licenses of any of the study countries. And I should mention it is also one of the most frequent users of government use licenses for pharmaceuticals. You can see there it has 5 broad grounds of relevance to medicines, really is number 4, to prevent or relieve a severe shortage of food, medicines or other consumption items, and number 5 for any public or other public service. So this language really is as broad as it can be to allow for the Thai government to increase domestic access to patented products or processes that is in the interest of the public. It does have a no prior negotiation required with patent holders for these licenses, but there is no export licenses allowed. Okay, next slide, please. So in Thailand, there has been quite a lot of access to medicine advocacy to and coalitions of access to medicine groups over time to try and push for compulsory licensing or government use licensing to increase access primarily to antiretroviral drugs. Thailand, back in 1999, there was quite a push to issue compulsory license for an antiretroviral drug to treat HIV, DDI, which was a really important drug at the time, because Thailand had and still has a very high prevalence of people living with HIV who at the time couldn't access medication because of price, and many people died without access to medicine. That initial push by advocates was unsuccessful in 1999 to grant a patent for DDI. However, they had success in 2006 when the Thai Ministry of Public Health issued a government use license for 3 drugs in close succession, the first one being for efavirenz, which was patented by Merck, for the antiretroviral Coletra, which was patented by Abbott Pharmaceuticals, and an anti-clotting medication, Plavix, which was patented by Bristol Myers Squibb. They then went on to issue 4 more compulsory licenses for cancer drugs, the last one being in early 2008. They were also the first country to issue a compulsory license for lower middle income country to issue compulsory license for a drug other than antiretrovirals. So there was quite swift pushback from pharmaceutical industry, the Thai pharmaceutical industry, pharma, US government, and particularly by Abbott Pharmaceuticals, who were the patent owner of Coletra, the antiretroviral, who were arguing that these government use licenses were not TRIPS compliant. In response to this, the Thai government responded with producing a series of white papers that outlined the reasons for issuing the government use licenses and how that they were actually consistent with Thai law, with TRIPS and WTO law. Those initial 3 government use licenses made a huge impact in terms of government saving the government over $370 million, and increased access for additional over 84,000 patients were able to access those 3 drugs over 5 years. Okay, next slide, please. Nevertheless, since early 2008, there has been no further government use licenses issued, and that has been suggested it was because of government concerns about reprisals from pharmaceutical companies. I should mention that Abbott Pharmaceutical Company, in retaliation, withdrew all the drugs awaiting registration in Thailand and said they would register no more drugs in a response to the compulsory license for Coletra. So for fear of reprisals from pharmaceutical companies, greater willingness of pharmaceutical companies to negotiate prices, and a general policy shift within the government from one of compulsory licensing to one of voluntary licensing. So in other words, there is, I guess, more to the puzzle and successful implementation of compulsory licensing than just the policy and the law itself. Other things come into play, especially politics, and all these must align in order for a compulsory licensing to be successfully issued. Thank you. And I'll hand back to Rachel.
To Brooke. Go ahead, Brooke.
Brooke, sorry, Brooke.
Thank you, everyone, and particularly to my co-authors, who I want to express how much I appreciate the work everyone put in to come up with this study, and particularly because, as Carlos said at the beginning, we've had lots of study on compulsory licensing, but I think not with the granularity that was and kind of creating of the major 3 categories that we've discussed. I don't think that really had been done in previous studies, and of course it was the hope and aspiration of all the authors working together to articulate the degrees of flexibility that are available, and to some extent encourage countries to adopt all of those flexibilities. The use of them is a separate question, but the ability to have the policy space to act when needed seemed to us to be a primary public health consideration. And people put in hundreds, maybe even, Rachel, thousands of hours to help this project come to fruition. So I want to express that appreciation at this time. And I do that in part. I'm a retired law professor, but I've also been an HIV/AIDS activist for over 25 years, working on access to medicines. I'm a senior policy analyst for Health Global Access Project. And the difference between the 20,000 people on treatment when I started my work and the 30 million people on treatment, 31 million people on treatment today is a testament to the kind of change in public health that can be occasioned when compulsory licensing is one of the tools the countries and companies use to overcome monopoly control. So our major findings and conclusions, and then I'll also be talking about some contextual factors and final recommendations. So first and foremost, there is substantial diversity to the extent to which, in the ways that countries have adopted and implemented compulsory licensing within their domestic laws. And of course, some of that is a result of colonial imposition and inheritance from colonial masters. Some of that is because of what historically had been quite limited forms of technical assistance from WIPO, which really for many years did not seem to have a strong development perspective with respect to compulsory licensing provisions and national laws. So we're stuck with this, and here we are so many years, 30 years post-TRIPS, and countries still have not amended their laws to incorporate all of the possible flexibilities, and we see that quite dramatically. But we also see that the various kinds of experimentation that have taken place and kind of proof of concept that almost everything that we discussed in the paper has some precedent in some national laws. There may be a couple exceptions, but mostly someone somewhere has done what we have categorized as important features of flexibility. But in conclusion, we saw that most countries had adopted, on average, less than 50% of what they could do in terms of the breadth of grounds for issuing compulsory licensing, the ease of use in requesting and granting them, and the scope of applications to granted compulsory licenses. And we are, confounded by the end conclusion that we have not maximized this policy space, despite Carlos could probably have a more accurate estimate of this, but I imagine tens of thousands of pages have been written about compulsory licenses and the law reform needed, and previous studies have certainly documented that many countries have not had good practice yet in their compulsory license law, and we still haven't achieved it. And we know that South Center and many other actors, UNDP in the past, but others as well, have tried to assist countries in amending their laws. And there have been some successful examples, but certainly not to the extent that we needed. Next slide, please. So I'm going to talk about some additional contextual factors that have confounded the use of compulsory licenses. And those are in 4 buckets: the realities of patent and trade secret landscape, the scope of internal and external political will and pressure, bottlenecks of regulatory requirements, and then the lack of technical and financial capacity and market size that stymies successful compulsory license implementation. Next slide, please. So these first 2 contextual factors, the realities of patent and trade secret landscapes. We know that companies create what are called patent thickets. They patent anything that move or that might move surrounding their core patents to keep competitors at bay. So there are many non-work patents that shield the patent holder of the product from competitive entry. They will patent around the patented invention that they're working. And then we also know that in addition to those kinds of defensive patents, there's evergreening. And evergreening is the patent for new formulations and new uses and slight variations in the chemical substance and combinations and on and on and on. And so we know that these evergreen patents extend or lengthen the effective patent monopoly by many years, far beyond the 20 years that are given to the initial base compound. And then we know that many products, increasingly true for biologics, but some other products as well, is that there are patents on some of the components. So we found this to be a big issue in the COVID-19 vaccines, that not only were the final products patented, but that there were many patents on underlying technologies like the lipid particles that were used to transport the active pharmaceutical ingredient. A fourth factor that complicates things is that the patent landscapes are opaque, both domestically and globally. Part of the problem is that there's a lack of requirement that patents indicate that they're on a particular pharmaceutical product, that they're relevant to it. So you can be searching for something and all you see in the search is maybe a chemical formulation or a component that is not directly tied to a final product. And so it's extremely difficult to determine all the patents that are relevant. And then, of course, it's also hard, even harder to know globally. And since the existence of global flexibility is important for many companies, particularly generics that seek to enter and find viable markets, it's important to know not just domestic freedom to operate, but also where you might be able to market. So these opaque patent landscapes make it difficult to navigate. And we know that for many of the compulsory licenses, you're actually required to list the patents. Not so for government use, not so for emergency, at least at the beginning, but for, let's call it an ordinary compulsory license, that you might need to do so. And then, a new concern that became particularly salient in the COVID context is the trade secrets and know-how for production. Small molecule medicines producers, including those in India in particular, are quite adept at reverse engineering small molecules and being able to produce them without any technology transfer from the originator. But for biologics, both with respect to the biological materials, but also because of the complexity of the manufacturing process, the so-called know-how, it's important to have access to that, or it's extremely expensive and time-consuming to come up with an alternative technology platform for high-quality commercial manufacturing. And so we know that the central problem with trade secrets is they're secret, and the companies get to define what they want to hold a secret. There's certain standards that are required, but they can claim trade secret and confidential information protections far before it's ever tested in court, and of course that's a problem. And it's not clear that there are many provisions at present for overcoming those secrets. There can be exceptions, kind of a general principle in trade secret law that public interest can trump in certain circumstances. People have written about the possibility of compulsory licenses. There's nothing directly for or against in the TRIPS agreement, and those of us who work in access to medicine certainly say if it's not prohibited by TRIPS, it's permitted by TRIPS. And so, people are encouraging countries to consider use of trade secret compulsory licenses. That's not the part of our study. We didn't really go into that in depth, but we do think it's important to mention it. And it's certainly an issue which makes simply overcoming a patent barrier in some sense incomplete or insufficient to actually being able to facilitate production by a generic or biosimilar company. So a second issue is the internal and external political will and pressure. So domestic political will is, how important is the health of the population to political elites in a country? Has there been advocacy by patients and their allies? Are there movements for access to medicines, which certainly is how we got to where we got to on HIV? Are there perceived cost savings by means of a compulsory license. What are frankly, the resource constraints and technical restraints? And so there's a whole bunch of things in terms of the domestic law and domestic realities, which are relevant, including the legal frameworks on right to health and recognition of a human right to health, or at least certain health-related rights under national law. But then, as Carlos and others have mentioned, and Bridget in particular with respect to Thailand, we have the external pressures, particularly strong and public in the case of Thailand. But there are many other examples in India, Brazil, Colombia, and South Africa. People may remember the infamous lawsuit by 39 drug companies and associations against the government of the new Mandela administration in South Africa, because they had a provision that would have supported a well-known flexibility parallel importation. Carlos, I thought, really helped us understand that there's in fact been a long history of government use by the United States, increased willingness by the European Union to support the use of compulsory licenses, including internally with new regional compulsory licensing provisions for emergencies. Since we wrote this paper, we now have the Trump administration, which I think the earlier with removal of U.S. pressure with respect to compulsory licenses is now reversed effectively, and that the U.S. is much more likely to exert political pressure than it was under the Biden administration. So that's an issue. I think that historically, the bark of the U.S. administration and Section 301 special reports with respect to the use of compulsory licenses was never matched with the bite. But I think this administration, I think it could be more problematic. Next slide, please. So additional contextual factors are the regulatory requirements, and this generally does not get quite as much attention from access to medicines advocates as overcoming intellectual property barriers. But there are complexities both in the global mechanisms and more particularly in national regulatory frameworks for emergency use authorization and the registration and marketing approval to verify and confirm that a product can be brought to market based on its safety and efficacy profile and its good manufacturing practices or built-in quality. The diversity of requirements and actually the paperwork that needs to be submitted and the standards in different countries' laws make it difficult for both originators and generics to register broadly. And as an example, we see now that Gilead, for a new antiretroviral medicines that's used for pre-exposure prophylaxis, a medicine injectable twice a year medicine called lenacapavir, they've only promised to register in 22 countries, low and middle income countries. And they're leaving it to eventual generic entries to register more broadly. A last technical issue to talk about is the technical and financial capacity and market size stymies successful compulsory licenses implementation. So countries have sometimes problems with respect to their own domestic technical capacity to issue compulsory licenses, in part because they haven't done so for so many years. And so there's just not, a good record of procedures to be followed. Countries may have, administrative law challenges and legal capacity challenges to manage their compulsory license petitions. A more important issue, frankly, in our estimation, is that countries may lack a domestic market that is sufficiently large to incentivize the generic entrant. And that can inhibit both the government in considering that, but more particularly they may not be able to find a licensee. And so, our recommendation with respect to this, and I'm sure this is something that the South Center has emphasized in many contexts, and as a sense, the whole rationale of its organization is that there needs to be more collaboration and cooperation on particularly on regional basis, to create aggregate large markets. And I think that this is the reason why in the current discussions of local production, so much of it is turned to actually regional production, to have regional production hubs that can serve an entire region with respect to a viable market and a market that has sufficient purchasing power to incentivize more than one generic entrant, preferably as many as 3, to maximize the benefits of competition on price. I want to emphasize one thing which I don't think we did in our presentation, but the issue of compulsory licenses is relevant not just to freedom to operate for manufacturing, but to aggregate a viable import and export market. You can't have a regional supply system if the importing countries have their own patent law blocks. The freedom to operate country and company can export, but will not be able to export actually and commercialize in countries where there's a blocking patent in place. So this is one of the reasons that we're emphasizing the need for regional collaboration and cooperation on compulsory licensing on key technologies, is that will be essential to create a viable import-export market where you can both have freedom to operate, but also freedom to export and import. We know that the medicine patent pool has played a role to some extent with voluntary licenses. We think that to some extent the compulsory licenses in some instances will result in expansion of voluntary licenses, but the actual willingness to use compulsory licensing is certainly important. And ultimately, the question of whether, a sustainable generic competition can be incentivized or not will depend on, whether the product can be sold at some profit, sustainable profit, and who pays for the product. And we know that the world has become much more complicated in that context right now because of dramatic reductions in foreign assistance for health that the Trump administration and multiple European countries have just dropped on the world this past year. Next slide, please. So, in conclusion, we came up with relatively narrow set of recommendations, but we think important. The first one is this is now restating what, in a sense, is obvious from our studies. The country should, as much as possible, adopt the full scope of TRIPS flexibilities for a more effective and easier to use compulsory licenses for access to medicine. All of the substantive flexibilities, all of the use of use flexibility, all the breadth of use. And so, this is just a key recommendation. And to restate what I said earlier, adopt it, and then you have a second decision of when and how to use it. But if you don't have the provision, then it's that much harder to implement the licenses when you need them. There needs to be technical support for countries excluded from voluntary licenses. At this point, it's actually upper middle income countries and occasionally even some lower middle income countries that are typically excluded from voluntary licenses. And those countries in particular should be getting technical assistance from key international organizations like the World Health Organization, like UNDP, for support for regional cooperation. And this, I think, is, though we didn't state this specifically in our recommendation, given the growing interest in local and regional production, it's even more imperative that these countries that are typically excluded from licenses. As a key example, 26 mostly upper middle income countries and territories are excluded from the Gilead license for lenacapavir. The license from Gilead excludes the licensees from supplying, even if they are beneficiaries of a compulsory license in an excluded country. And so that, that's a horrible provision in that contract. But it means that for those 26 countries, if they want to create viable import markets, export markets, are going to have to collaborate. And it's important for other institutions to support them in those efforts. Finally, we think there needs to be much more south-to-south collaboration and coordination and cooperation. There is existing capacity and know-how in countries about compulsory licenses. We have many examples where compulsory licenses have been issued and countries have stood up to the threat of retaliation, including quite recently on an important AIDS medicine, dolutegravir. So we think that the law and reform efforts will be enhanced when countries cooperate, and particularly when they can do so through mechanisms such as those offered by Carlos Correa and others at South Center, who provide very important technical support to countries in this regard, as well as the aforementioned World Health Organization and UNDP and others. So we think that a fourth recommendation is that there needs to be attention to adoption of supporting and enabling companion policies. So particularly regulatory requirements that we mentioned briefly. We have to reduce the complexity, cost, and delays of regulatory systems. Much greater use of the WHO Collaborative Registration Program, which draws on once there's been pre-qualification at WHO, then there can be expedited sharing of dossiers and decisions with countries and decisions within 90 days. Other recommended enabling policies include clinical guidance, workforce training, adding more medicines essential lists, and several others. It would be ideal if there could be reform of the TRIPS agreement. We didn't spend a lot of time, and we know how difficult it is to amend the TRIPS agreement. But we think that the predominantly for domestic use provisions of Article 31F and the Article 31 bis export and import for countries with insufficient manufacturing capacity are barriers to the effective use of compulsory licenses. You just should not have to jump through a whole bunch of additional procedural hoops, as you have to do with Article 31 bis, which has been used only once since the initial waiver under line 31 bis was adopted. It should be simple to manufacture and supply countries where no patent exists or where a compulsory license has been granted. And it's deeply unfair that a big rich country like the United States, which has ample domestic supply, doesn't have to worry about needing to export from somewhere else. But Lesotho and Mozambique and many smaller countries can only really source from other countries, and they have restricted capacity to do so. Then finally, we think that there should be further research on the ways to implement compulsory licenses into national law. We try to do the best we could, but we may not have covered everything that needs to be covered. We certainly need to also understand what are some of the practical barriers to the law reform process and try to figure out how we overcome those barriers. I think that's it. Do we have another slide?
Yeah, that's it. Thanks, Brooke. Thanks all of you for sticking with us. I believe I turn this over to the South Center now for the next step.
Thank you all for that wonderful presentation. We now have the pleasure to also have here with us to give some comments with regards to the publication from a Colombian lawyer who's also an LLM from the University of Andes in Colombia and a master's in economic development from Erasmus University in the Netherlands. He's been an advisor to the Ministry of Foreign Affairs and to the Office of the President of Colombia He's also been Director of Foreign Investment Services and Intellectual Property at the Ministry of Commerce. And currently, he's the Deputy Permanent Representative of Colombia's mission to the World Trade Organization. So we have Nicolas Palau with us. Nicolas, pleasure. Please go ahead.
Thank you, Viviana. Good afternoon or morning to everyone. Thanks to the South Center and to the Global Development Policy Center of the University of Boston for this opportunity to comment on this paper. Let me just 1 second to show a small presentation of my comments. The South Center has asked me to provide some comments from the perspective of a public servant. We are one of the actual final destinies of this type of research paper. And having read it, I find it quite stimulating. I will make 8 comments on it. They will be brief comments, but I hope that they can be enriching for the authors, to whom I thank a lot their presentation and the great work that they have done in the past. My first comment is that this should become compulsory reading. Actually, I think that the research paper can become one of those canonical papers that everyone reads when it's interested in this type of issues. Not just because of the research question and how the authors address the research question, but also in the first part, in the diagnostic part, in the explanatory part, in the recommendations part, in the historical part. There is, you can see like a source of sources type of paper. One of those papers that it's elegantly written and very well explained, that should be read by every public servant that is involved to these compulsory licensing issues. So definitely, I hope and I think and I guess that it will become one of those compulsory readings for students and public servants and academia alike in the next few years. A second comment is that it's been quite refreshing for me to read a paper that is focused on the upper middle income countries or middle income countries, or what we call normally the sandwiched countries. Most of the literature is normally related or to the developed world or to the least developed countries when addressing the issues related to access to medicines. And upper middle income countries or sandwich countries, which are not too big or too small, can have additional issues, different issues on top of the normal issues that developing countries can have when accessing medicines through different tools. So it was quite refreshing to see a paper focused on this sandwich type of countries. Third, we found very enlightening the broad range of ideas and possibilities that the paper has included. The actual syllabus of the different tools that governments can have in the realm of possibilities of compulsory licensing is quite sophisticated and quite eye-opening. Normally, when you are a public servant, you focus too narrowly on your pet struggle, and you say, okay, we need to do this, and you start doing it, but you forget most of the time of a lot of other possibilities and a lot of other important tools that needed to be included in a broad range strategy for maximizing the compulsory licensing schemes in our countries. A fourth comment is that we think that the ranking idea it's very clever. It's very clever. Normally, personally, I don't like much rankings because you start just doing the ranking and not trying to change the reality below it. But the truth is that rankings are drivers for movement, and they are engines for action for public servants. So whenever you are a new public servant and you arrive to a posting in your government, this type of rankings make a framework of what is possible, what needs to be done. You go to symposiums in which you see your colleagues. There is some emulation and mirroring competition. They are actually and genuinely drivers for movement. So I really like the idea of making it an index and a ranking that can be improved and then that provides some sort of north to new public servants that arrive to the issue. Even if they know a lot about the topic, this type of north illuminating rankings can be very, very useful. A fifth comment is that this is all related to compulsory licensing, but it can also have a very important potential positive impact in the negotiation of voluntary licensings in our sandwiched countries. Normally, the table for negotiation of a contract of licensing is quite asymmetrical, is quite unleveled. Normally, the company has everything that the country or the company in the developing country or in the sandwich country needs. And this type of negotiation is never an easy one, and it's so lopsided that the actual process of persuasion and negotiation is difficult in this issue. And compulsory licensings provide a tool to level that table of negotiation. This asymmetricality becomes a bit less complicated when there is a possibility of invoking a compulsory licensing scheme as part of the negotiation tools that public servants can have in the table. So most of the time, compulsory licensings and having the broadest scope possible for compulsory licensing and maximizing the policy space that compulsory licensing have is useful, not just because it's useful in itself and they maximize the potential impact, but their mere existence is good for the negotiation of voluntary licensing schemes by private sectors that involve international actors, one from a developed country and one from a developing one. So on top of providing tools to the government, the sole existence of these tools provides a good leveling playing field for other types of factors related to medicines licensing of technology. Sixth, and this is a suggestion, when you see the list of what needs to be done or what should be done to maximize the flexibilities that countries have, there is one that you mention in the paper, but it's mentioned only in the diagnostic part, and it probably can become one of the indexed and ranked solutions and give, I don't know, 3 points to it. Because it's quite it could be quite an important tool to maximize the potential of compulsory licensings in middle-income countries, and it's related to the inclusion that the United States have made in most of their procurement contracts, in which they have included a provision that allows or opens up the possibility of having a short and sharp compulsory licensing for the products that are being procured. So we think that having that provision in the model contract of procurement in the middle income countries should be part of the strategy for maximizing the compulsory licensing schemes and should provide 3 points to those that can have it. I don't know if this type of idea could be included in the flexibility, in the procedural flexibilities part or in the scope of application part, but in any case, it's a useful policy tool inclusion that might be suggested to be added to the actual ranking. A seventh comment is also a suggestion for adding a tool, and it's related to, this is probably a bit more difficult, but it's related to Article 40 of the TRIPS agreement, which is one of the most forgotten articles of the TRIPS agreement, which is it's not explicitly related to compulsory licensing, but it's related to voluntary licensing, to schemes to make better the voluntary licensing contractual provisions. So it's, at the end, it can become also part of what compulsory licensing schemes can adopt. There's even a mention on that article on coercive package licensing and some other options or ideas that are in the TRIPS agreement, that are not just discursive, but are part of it, and that can maximize even further the space for compulsory licensing when used appropriately. So maybe just a small exercise on interpreting the Article 40 or looking some tools that can use or take profit of this provision of Article 40 in the context of compulsory licensing can become also a 3 points extra type of solution. And finally, this reading this has been for me so enriching that I would be glad to have this type of research paper or report paper, and not just focus on compulsory licensing, but in general on all the flexibilities of the TRIPS agreement. It would be a boon to have like the Bible of maximizing policies on TRIPS flexibilities, because you can also have this type of exercise and this type of ideas regarding the exclusions, regarding the exceptions, regarding the part of injunctions and judicial reviews, etc. So at the end, having like the broad universe of how to maximize the policy space in general, and in particular on compulsory licensing, would be fantastic from the perspective of a public servant in the future. I know that the focus is narrow in this report, but this type of exercise is quite well received from the perspective, from our perspective. So these are our main comments. We really thank the authors and the South Center and the Global Development Policy Center to have invited us to comment. I really hope and think that my first comment will become a reality in the next few months and years. Thank you, Viviana, for giving me the floor.
Yes, thank you. I think it's my turn now. We only have a handful of minutes, and unless Carlos, did you want to come in and close this up?
Well, thank you very much for the presentations. I think that the study has been shown as a very useful tool, not only for the 15 countries that have been studied, but also for other countries that may follow the recommendation that you have made, and also understand the findings that you have made. So thank you also, Nicolas, for your very valuable comments and the additional suggestions that have been made. I think that those are quite interesting and show your deep knowledge also of the system. And of course, we would like to continue working with the Center of Boston University And also, as it was mentioned, there are opportunities to assist developing countries to improve their legislation in order to make an effective use of compulsory license. Certainly the South Center will be very much interested in cooperating with that. So again, I think this study is unique, and we are very, very happy with this collaboration. Thank you, Rachel.
Thank you, Carlos. Thank you, Viviana and Ana, again at the South Center. Thank you, Nicolas. Your contribution was extremely helpful, including your suggestions for taking this further and extending the study to other flexibilities, adding other compulsory licensing options. So we're going to be taking a look at that for future research. Really helpful to hear from you. Thank you so much, everyone, for participating and listening.
Okay. Goodbye, thank you.
Gracias. Thank you.